Thank you all again for joining today's webinar brought to you by the Tribal Law and Policy Institute and the Tribal Judicial Institute UND School of Law. Today's webinar is titled Criminal Sentencing in Tribal Courts and Post-Sentencing Options, presented by Michelle Rivard Parks, Associate Director of the Tribal Judicial Institute UND School of Law. I will now turn it over to Michelle to introduce herself and to get us started.
Hello, everyone, and welcome to today's webinar. I am going to keep my video feed off just for bandwidth purposes and to hopefully avoid any disruptions to today's presentation. Just by way of introduction, my name is Michelle Rivard Parks. I serve currently as the Associate Director at the Tribal Judicial Institute at the University of North Dakota School of Law. I also teach courses within our Indian Law Certificate program at the university. I'm teaching classes in tribal law. I've taught classes in federal Indian law and tribal economic development and the lawyer. In addition to the work that I do as part of the Institute, I am a former tribal prosecutor. I have also served for a little over 25 years, I think, as legal counsel for one of our tribes here in the state of North Dakota. And I have, for the last 10 years, served as the Chief Justice for the MHA Nation Supreme Court, which is a tribe also located here in North Dakota. And so today, what we wanted to discuss with you is a little bit about sentencing, particularly what we wanted to talk about was to give you an introduction and get us all working on the same page and understanding about the sentencing options that exist within our tribal courts and under our tribal laws, and then also incorporate into that some discussion about the impact of the Indian Civil Rights Act, both prior to the Tribal Law and Order Act going into effect and the amendments resulting from the Tribal Law and Order Act, and then after as well. So in that regard, we will be discussing a little bit about enhanced sentencing authority. We're also then going to move into a little bit of a discussion about some of the terminology that's used when we're sentencing, the importance of making sure that we are including these definitions and references within our tribal court orders as tribal judges. We'll also talk a little bit maybe about some of the pros and cons of some of the sentencing options. And we really want to focus a part of our discussion also on amending and changing sentences that have already been put into place by the courts. And we believe that this is going to become more and more of an issue on down the road and as tribes are implementing enhanced sentencing authority. So let's start first talking a little bit about the purpose of criminal sentencing. And, the purpose behind criminal sentences might vary a little bit from tribe to tribe, but in a general sense, criminal sentences are going to be put in place to both deter um, future criminal activity and also to impose a sense of retribution for a victim and for the community, and maybe to also serve as a form of punishment for an individual who commits a crime within our tribal jurisdictions. So there's a variety of different kind of goals or purposes for criminal sentences generally. And so sentencing options and having sentencing options available to our tribal courts are going to hopefully allow our tribal courts to both hold defendants accountable when they are committing crimes. And when we say accountable, we mean accountable both to the victim and to the larger community. Because we do know that even though crimes may be occurring against individuals, there's a ripple effect that flows throughout the community and impacts community safety. Sentencing options are also hopefully going to serve another purpose, and that is to provide opportunities for defendants to change their behavior, and to reduce the likelihood of recidivism in our tribal communities. So, we don't want to have our criminal courts be a revolving door where we have the same individuals coming before the court, repeating criminal activity over and over. And so, if we're being effective in the sentences that are imposed and the sentencing options that are made available, hopefully we can achieve this balance between accountability or punishment for bad actions, as well as providing opportunities and tools and resources to stop criminal behavior and future criminal behavior. And the other thing that we kind of have to note or be aware of is that although we have some really state-of-the-art detention facilities in parts of Indian country in this nation, there are also a lot of tribes that are without detention facilities. Either they don't exist at all, or they just don't exist for certain court-involved individuals, such as juvenile offenders, or, do we have male facilities, female facilities, etc. So those types of options can be challenging for some tribes. And so coming up with sentencing options can help to make sure that what facilities are available, that we're using those for the people who really need them and the people who really need to be separated from the community, both because of the punishment aspect of the crime that they have committed, but also to ensure community and individual safety moving forward. So I had mentioned early in our slides that one of the things we would be talking about are sentencing options, and I mentioned the Tribal Law and Order Act. I think a lot of you who are participating in today's webinar are probably familiar with the Tribal Law and Order Act, but I also know that some of you might be new to tribal criminal systems. And so having an understanding of the intersection of these federal laws and how they play a role in what types of sentences the tribal courts are able to impose when a crime occurs and an individual has been convicted is important. And so the Tribal Law and Order Act was passed in 2010. And there were several provisions within the Tribal Law and Order Act. We're going to focus in on one section of the TLOA, or the Tribal Law and Order Act, wherein the TLOA amended the Indian Civil Rights Act. And in doing so, what it did was it opened the opportunities for tribes who had certain um, provision tools and resources and infrastructures in place. Those tribes were able to um, impose what are called enhanced sentences for qualifying crimes. And so, when we look at the Indian Civil Rights Act prior to 2010, there was a limitation in the Indian Civil Rights Act that indicated or stated that tribal courts were able to impose jail time of up to 1 year and a fine of up to $5,000, or both, when an individual committed a crime and the individual was convicted and sentenced in a tribal court. Now, after 2010, and with the amendment to the Indian Civil Rights Act, for the tribes that had these certain infrastructure pieces in place, those tribes would be able to impose sentences that exceeded 1 year, if there was a qualifying crime. And so behind this, there's a few considerations. Some tribes have opted not to impose enhanced sentences or to build that capacity. Other tribes have opted to impose enhanced sentences and to, revise their codes, revise their sentencing provisions to enable their tribal judges to do that. One of the considerations I think that people are taking a look at is that Native Americans are already incarcerated at higher than average rates. There's a reference here that in federal and state prisons, that is exceedingly high. And so for some tribes, the idea of further incarceration or going down the path of increased sentences is not something that's appealing. And so they've opted not to do it. Some other tribes, though, have felt that there is a need, at least for, particularly violent crimes, or crimes that are really negatively impacting community safety. Some tribes have said that yes, they want to move forward, and they have moved forward with building capacity to impose enhanced sentences. Um, and so that's been kind of an ongoing discussion for each tribe to decide for themselves whether or not they want to build this capacity or not. And for those that have, I think what they're also now starting to see is that once a longer sentence is imposed on an individual, so let's say an individual is sentenced to 3 years in jail instead of 1 year in jail, we're now having people come forward and say, but wait a minute, are there ways to reduce those sentences? Are there provisions within our codes that allow for uh, the commuting of a sentence or for paroles or pardons? Are there ways that we can, or provisions that we should have in our law that allow for the restoration of civil rights of defendants who have maybe been incarcerated for these longer periods of time and who are now released into the community and have served their time and are reformed? And so it's really kind of that latter part that we're going to talk a little bit more about today. And we're going to give you also some examples of tribal codes that where tribes have started to put provisions within their codes to guide the court and provide information and factors for the judges to consider when looking at whether or not a sentence that's already been imposed should be changed in some manner.
Michelle, we do have a question that might be relevant. And the question is, do those justifications for punishment comport with most tribal cultures? Retribution and punishment are more of a Western adversarial approach to the criminal legal system.
Yeah, I think that's a great question. And I think that's a part of the dialogue that's happening within each of the tribal communities when they're deciding whether or not to impose enhanced sentences or not. I could tell you that this will kind of go back to some of the work that I've done for tribal law within our law school. One of the things that we learn and we study early on is kind of looking at examples of tribal communities and how tribal communities might have handled or addressed bad actions or prohibited conduct in their communities prior even to colonization. And although it is absolutely true for some communities that the idea of things like incarceration would not align with cultural values, there are many tribal communities that did historically impose punitive measures for certain types of bad acts that occurred. And so that's really, I think, a part of the discussion that each tribe would want to have when looking at, what kind of sentencing options to include in your tribal codes that you think will be effective in achieving whatever your sentencing goals are. And so again, like those sentencing goals, they might not be to punish an offender. It might be to deter criminal activity. It might be to restore harmony and balance to the community. But those sentencing goals are something it's at least important to discuss, and that I think that will help the framers of your laws and your codes to really build out sentencing options that are helpful for your community. So I want to kind of move into a little bit of a discussion on some of the basic sentencing terminology that we're seeing in our tribal criminal courts. And I'm also want to kind of point out this leads in a little bit or kind of follows up a little bit on that question, but also I think leads us into some of the terminology that we're seeing. For a lot of our tribal courts that are exercising criminal jurisdiction, a lot of those crimes are being addressed in an adversarial court setting, very similar to what we see happening in state and federal courts. And as tribes are building their court capacity, we are seeing more and more courts taking on and adjudicating very violent crimes oftentimes and crimes that are really detrimental to the tribal communities. And some of them are the types of actions that may not have been common or have occurred at all historically. And so as kind of these new things are happening, tribes are building out responses to things like drug trafficking, to things like foreign drug cartels moving illegal substances through tribal communities, and also some of the violent conduct that intersects with that. Tribes are adjudicating cases that involve, sexual assaults, crimes that are being perpetrated against children, crimes that are being perpetrated by non-Indians if it's within the scope of a tribe's special tribal criminal jurisdiction authority. And so there's a lot of different kind of components to building sentencing options. And I think when we look at the diverse nature of the types of criminal activity, we also want to have sentencing options that align with the different types of activity and are appropriate, given the different types of criminal activity. And so in some instances, tribes, for example, are saying they want harsher sentencing opportunities in terms of incarceration for violent offenders, but when they have someone who has a possession of marijuana or some other, prohibit alcohol or public intoxication, they don't want those types of folks incarcerated. Instead, they want to build out treatment and service options for those people. So it is a complex portion of our discussion when we think about sentencing options. But when we're within our tribal courts, a couple of things just to be kind of cognizant of and is that we use some different terms. So when we look at the term executed sentences, what this typically refers to is a flat time sentence where, an individual is convicted of a crime and the judge says in the sentencing order, you are sentenced to 30 days of incarceration. And that's just a flat sentence. There's nothing else to it. When the individual is taken from the court, they'll typically have either a report date or they'll be taken directly to the detention facility. They will serve out their 30 days and that will end their sentence. We might also have what are called suspended sentences. And this is really going to be a sentence that where if there's a measure of incarceration that's included in the sentencing order, all or a part of that incarceration time might be suspended. And I think this is a pretty common one. At least in my time as a prosecutor, we would see a lot of this where an individual would be convicted of, I'll say, individuals convicted of domestic violence. It's a first time offense. They're sentenced to 30 days of incarceration, and 20 of those days are suspended so long as the defendant completed some form of, re-education programming or whatever service the court might require. And of course, with a suspended sentence, if the individual doesn't complete that condition of suspension, then they would have to serve out the remaining days of their sentence. We also have what's called a suspended imposition of sentence, and this is where we may not have an actual sentence that's imposed on a person, and instead, what the court will do is they will suspend the sentencing process. and oftentimes they will divert that person over to like probation, or suspended impositions of sentences are also common when we see people being referred out to diversionary programming or diversionary courts. And with the suspended imposition of sentence, a lot of times, if the court goes down this path, if the individual is diverted out and they successfully complete the programs or services that they're directed to do, it may result in the court expunging, the case altogether, or the conviction altogether, and it may also would just mean that the individual does not have to serve any time in jail. Some ongoing terminology, and these were some things that we wanted to discuss a little today with you are, we oftentimes think about an individual is charged. If there's a conviction, we move on to sentencing, and then after sentencing, the individual will either serve time in jail, and or be placed on supervised probation or something of that nature. But what we don't often talk about within our tribal codes and our tribal communities are sentencing modifications, are commutations. And what we're referring to here is when we're asked to change a sentence after it's already been imposed. And usually this results or comes back before the court because there's been a change in circumstances. So, for an example, if a defendant is convicted, and they are sentenced to 1 year in jail that they're supposed to serve, but while they're incarcerated, during that year, perhaps they develop an illness, or perhaps they complete a program within the detention facility. And so their circumstances have changed. They may then, if it's allowed by tribal law, come back to the tribal court and ask for a sentencing modification or a commutation of their sentence. Pardons are another term that I think it's important for us to become familiar with, particularly if a tribe is considering imposing enhanced sentences or these longer sentences, terms of incarceration. But also, if there are collateral consequences based on a conviction. And I'll kind of talk a little bit about that. But what pardons are is that refers to really a forgiveness of the conviction, and will result in a restoration of the civil rights of a defendant. A lot of times this is done by an executive branch of the tribal of a government. So you see, like, for example, in the United States, the president of the United States has the authority to pardon. When you look at a lot of the states, that authority rests with the governor. Within a tribal government, it might rest with tribal councils. It might rest with your chairperson, or your president, whatever the name of your executive officer is for your tribe. But there are some examples of this too, of pardons being found within tribal law. And then expungement. And the expungement process refers to the erasing of the conviction. And, it's really that usually to get an expungement or to get something erased off your criminal record or off an individual's criminal record, there are usually some specific requirements that have to be met. And to know what those requirements are, you would need to look to your tribal code. And first of all, in your tribal code, you'd want to see, is expungement an option? And if expungement is, what are the basic factors or requirements that must be met before a conviction could be expunged from an individual's record? Okay, so now that we kind of have talked about, the difference between sentences, the different types of sentences, and, the idea that we can suspend some sentencing provisions, we can defer imposition of sentences after a sentence is imposed, that there are, might be mechanisms, legal mechanisms that can be put in place to allow the court to revisit or change. I want to talk a little bit then further about some of the common sentencing options that we see. And so when we look at a lot of tribal codes will, have information or have provisions that allow the tribal court to impose a period of incarceration or jail time after an individual has been convicted. The amount of jail time will vary from tribe to tribe, and largely, again, that will be dictated by whether or not the tribe has implemented enhanced sentencing authority under TLOA and the Indian Civil Rights Act or not. Um, and for some tribes, they may have just opted to even do less than a year, right? When I was prosecuting, and some of those provisions in the tribe that I was prosecuting in continue to date, even though the tribe was able to sentence an individual for up to a year of incarceration for certain types of offenses, the maximum might be 6 months, it might be 3 months, it might be 30 days. So we always want to take a look at our sentencing provisions in our tribal codes to see what kind of sentencing options are there. But jail time is common. Fines are also common. And restitution, as you'll see here, is also another one that is often an option, particularly when there's a victim of a crime that has suffered some sort of damage, whether that be, incurring medical expenses as a result of an assault. Um, whether it be that they were the victim of a property crime and they've, experienced damage to property, restitution is another option. It's important to note too, we have a big difference between fines and restitution, right? Because when we're talking about fines, those fines are payable to the government, essentially to your tribal government. They get paid to the tribal court. The tribal court collects those fines, and then depending upon tribal policy or law, those fines, that pool of money will be reprogrammed in some way by the tribe. Whereas restitution is typically collected by the tribal court, but is that money is then passed along to the victim. So it's not something that goes to the government, right? We also have probation. I think it's really important that our tribal judges, do what they can also to learn what they can about probation and how probation functions within their tribal community. I recognize that not all tribes actually have probation departments still. I know that for example, a couple of the tribes here in North Dakota do not have active probation departments. But some tribes have, very robust probation departments with a lot of employees and capabilities to supervise offenders. But for tribal judges, it's really important that we understand the difference between supervised probation and unsupervised probation, and that we manage expectations and we place information in our sentencing orders that's realistic. It may not be appropriate to place every person convicted of any crime on supervised probation, because that probation officer is going to have case planning. They're going to have to follow up on a lot of different services for those individuals, and it just may not be necessary or appropriate. And again, this comes back to being considerate of the resources in your community, how those resources are being utilized, and making sure they're being utilized in the most effective way. So, really looking at who would benefit from supervised probation and who would not, and who needs it and who does not. So for example, you've got someone who comes before you with a first time offense, no criminal priors, no violent behavior, or risk of safety to the community. That individual may not need supervised probation, right? So just being mindful of that as tribal judges is important. Also, there are other things that we can look at too, directing people to individual services for completion of evaluations. If the judge has concerns about chemical dependency, substance misuse, if they have concerns about the mental health of a defendant, or if the nature of the criminal activity indicates that the individual would benefit from specific services such as batterers re-education. The tribal sentencing order can certainly do all of that. And then also I want to mention here too, when we're looking at our sentencing options, and what's going to be made available to the judge to look at, doing some resource mapping in your tribal community is really helpful and can be very helpful to making sure that the judge is able to effectively link individuals to helpful and necessary services in the community. And when you're doing resource mapping, be mindful of what are some of the cultural or spiritual or traditional resources in your community. Some tribes, for example, have linked individuals with elders programs, and through that have built out a measure of community service. That's really kind of it's community service, but it has a cultural piece to it. There are other tribes that have included or developed culture camps, particularly for youth and for those, and so those kids that are court involved and have been adjudicated delinquent, they might be linked to the culture camps where they are learning things like language, where they are learning subsistence skills, where they are being guided by mentors within their community, where they are learning about and strengthening their sense of self and their sense of who they are within their larger community. So we've got this list here, but please don't have this be an exhaustive list, and always be mindful of some of those other resources that might be available to you. I've already kind of mentioned the fines and court costs. The one thing I do want to, kind of reiterate as well here is that with that Tribal Law and Order Act in 2010 and the changes to the Indian Civil Rights Act, for those tribes that are implementing enhanced sentencing authority, it didn't just impact the amount of jail time that could attach to certain crimes, it also impacted the amount of the fine that could attach to those crimes as well. So, it's always, well, for many years under the Indian Civil Rights Act, and for tribes that are not implementing enhanced sentencing authority, it's, an individual crime can result in a sentence of up to 1 year, a fine of up to 5,000 as determined by tribal code. And if the tribe is an enhanced sentencing tribe and they are imposing enhanced sentences, they can now sentence for those crimes 1 to 3 years with a stacking ability of up to 9, and also fines of up to $15,000 for individual offenses. So, it has changed the sentencing options for the tribal courts. If they choose to do so, and if they choose to put certain infrastructure pieces in place. But again, not all tribes have done that. One other thing to be wary of when we look at these fines, there are provisions within the Indian Civil Rights Act that, uh, prohibit the imposition of things like excessive fines. And so 13027 of 20 Title 25 of the United States Code is where you're going to want to look, and you'll see, those provisions and what the limitations are. Um, Another option might be civil forfeitures. That's an option for criminal sentencing. But again, if civil forfeitures, so for example, we'll see things like if there's a drug crime, drug trafficking, and there's a vehicle might be impounded and then forfeited if it's used in the commission of a crime. For some of our tribes, we have tribes up in, our region in Minnesota, land of lakes, right? We might have the commission of crimes using boats or off-road vehicles. Those types of things might be subject to forfeiture if used in the perpetration of a crime. And so having civil forfeiture procedures with some level of due process, particularly if there's a third-party property owner, that would be important. And what do I mean by that? The example of that would be John takes a vehicle and drives it to sell um, illegal substances and gets busted by the police, right? He gets arrested. And so that vehicle was used in the perpetration of the crime, but the vehicle is titled to Sally. Sally is his girlfriend, right? So Sally would be the third property owner, not actually a party to the crime itself, but could be impacted through civil forfeiture. So if you're going to look at things like civil forfeitures as options, just be cognizant that third parties might be impacted. And so if that's the case, you would want to have something in your tribal code that allows that third party to be heard by the court before the civil forfeiture goes into place. And then another, option that I think I've seen in a lot of the tribes in our region, is exclusion or banishment. Sometimes this process, I've seen it both ways in different tribes. Sometimes the exclusion happens by action of tribal council, and sometimes the exclusions happen by order of the court. And that really just depends upon how your tribe has developed your exclusion or banishment provisions or ordinances under your laws. And so if exclusion may or may not be an option available to the tribal judge. Okay, and I've kind of gotten into this. Sometimes I do get a little bit of ahead of myself here, but we wanted to kind of I've mentioned to you this Tribal Law and Order Act and these enhanced sentencing provisions. The one thing that I mentioned is that, we've had this increase in the amount of fines and the amount of jail time that can be imposed through a tribal court sentencing order if the tribe has moved forward with implementing enhanced sentencing. The one thing that is important is that there has to be a qualifying crime charged in the tribal court. And the tribe also has to have specific due process protections for defendants. So we wanted to talk a little bit about those as well. And so when we look at the actual provisions of the Indian Civil Rights Act as they read now, and this is the enhanced sentencing provisions. The less than 1 year is still there, right? But the tribe can, if they want to do the enhanced sentences, increase them if the individual has been previously convicted of the same or a comparable offense by any jurisdiction in the United States, or if the individual has been prosecuted for an offense that would be punishable by more than a year of imprisonment if it was prosecuted anywhere in the United States. So, like if you can go on record and you can find that there's a state or or a federal law that would impose a sentence of more than a year for littering, you could put that in your tribal code if you are an enhanced sentencing tribe that you too will, subject someone to more than a year for littering, right? It's, there's going to be some offenses that most offenses you're going to know or you have a good idea, right, of whether or not if an individual is convicted of this offense in the state, would they be subject to more than a year in jail? If the answer is yes, then certainly the tribe is able to do the same. So, that's kind of important provision for you to know is that enhanced sentencing authority is reflected in the Indian Civil Rights Act. The tribe would need to decide whether they want to implement it. It might require some amendments to your tribal codes and tribal laws to ensure those due process protections that are required are in place. And then also it will require looking at the types of offenses to which these enhanced sentences would attach and making sure that they comply with these provisions. And this is,
Michelle,
yes.
sorry to interrupt. We do have another question that I think is relevant as well. Um, it's what is the effect of tribal expungement on enhanced sentencing based on violation of the same or comparable offenses?
Expungement on it. Okay, so Yeah, okay. So we'll get a little bit into expungement here in a moment, but that's really, I think, why we wanted to bring forward some of today's topic and reintroduce this topic is because when we are looking at individuals who might be being charged and sentenced to enhanced sentences, um, through the tribal courts, they might be serving 3 years, they might be serving 6 years, they might be serving 9 years. And it's really up to the tribe to determine um, whether or not to allow expungement of particular types of convictions. There's no prohibition that would say a tribe cannot expunge the record of an individual who's been subjected to an enhanced sentence. And that's really something just for the tribe to consider. And a lot of times when we look at expungement provisions within codes, it'll have very specific factors. So I'll give you a quick example. Let's say that your expungement provision says that in order to qualify for expungement of your tribal conviction, it cannot be a violent offense. And if the individual was convicted of a third time DUI, for example, and they were sentenced to 3 years of an enhanced sentencing under enhanced sentencing authority. That individual, it's a DUI, it might be considered nonviolent, so they might be eligible to apply for expungement if the code was drafted as I stated. However, let's kind of move to another type of offense. If an individual has a third time conviction of domestic violence, and they were sentenced to an enhanced sentencing authority term, and they want to have their conviction expunged at a later time, they probably would not be able to do so because, as I stated, the tribal code, as I just kind of gave you the example, would preclude anyone from having expungement of what would be deemed a violent crime. And so it's likely that a DV would be a violent crime. But again, those are just examples. And I'm not saying that that's how your expungement provisions need to read. That was just an example of how it could be. Now, it may be that your tribe has an expungement provision that does not uh, distinguish between violent and nonviolent offenses. And if it doesn't, and it just says factors to be considered was how long ago the crime occurred, whether the individual has had any criminal activity since that date of conviction, whether they've been gainfully employed or whatever the factors might be. If those are the factors for expungement, then under that example, both of the individual cases that I just described would be eligible to apply for expungement. So that was a very long-winded way of saying that the Indian Civil Rights Act does not preclude in any way an individual from having, or the tribe from expunging records, tribal records, should they choose to do so. But yeah, to be clear though, of course, we're only talking about their tribal criminal record. Of course, the tribal courts would have no authority to expunge any federal or state convictions. And okay, so kind of getting back a little bit to that provision we just talked about, which is that you can impose if you are an enhanced sentencing tribe and you've gone through all the steps you need to implement enhanced sentencing, and you want to impose a sentence of more than a year. Oftentimes, when we look at crimes that are subject to more than a year of incarceration, um, the term felon will attach a lot of times to that. But I want to be really clear about something is that the Tribal Law and Order Act nor the Indian Civil Rights Act use the term felony. But this is the common law definition for felony. But one of the things that some tribes have opted to incorporate felony delineation in their tribal codes, other tribes have not. And one of the reasons that some tribes have opted not to is because of the collateral consequences that can impact a person if they're designated to be a felon. And so there are, for example, collateral consequences where it might say that if you're a felon, you cannot vote. If you are a felon, you do not qualify for services. If you are a felon, you do not qualify for student financial aid, right? So those are things that kind of are collateral to the sentence that was imposed. enhanced, but it can really negatively impact people after they've even served their sentence and after they've been held accountable. And maybe even can serve as an obstacle if they are trying to, get their life on track or, do something. And so when we start to look at this also is where we'll see that there may be a need for tribal code provisions that allow for modifications, commutations, parole, pardons, expungement, etc. The other thing that's important, as you're looking at your sentencing options and particularly looking at these enhanced sentences, you might be saying to yourselves, yes, there are a lot of these violent crimes that are happening. There are drug trafficking crimes. There's all these types of things that are happening. And so we want to have harsher sentences because what we're doing now maybe isn't working for certain individuals. Keeping in mind that when an individual is sentenced to an enhanced sentence, there are some requirements that must be met in terms of where that person is housed. So, if an individual is sentenced by the tribal court to serve a 3-year term, that 3-year term of incarceration can only be served in a facility that has been approved by the Bureau of Indian Affairs for long-term incarceration, or it might be in a federal facility if they're part of a pilot project, or if it is another off-reservation facility which the tribe contracts with and which is appropriate for housing long-term inmates, because there are different kind of rights that come into play when you impose these long terms of incarceration. And so this kind of is a continuation of some of the other, besides the BIA facilities, a long-term incarcerated inmate can be also serve that time in a federal facility, in a state or local government approved detention correctional center, or in a alternative rehabilitation center of the Indian tribe. If and some of that all kind of impacts, whether or not it's even feasible, particularly when you think back to the beginning of today's webinar where we were talking a little bit about, that accessibility to detention can be a challenge for some tribes. So as we're kind of closing things out here, I wanted to give you a few examples of the field of sentencing provisions, where you can see examples. These are not, these are just some that we had our law clerks pull for us so that you could kind of look at them and you can see some of these examples. If you're looking at revising or updating your codes and you're not sure whether these types of things have been defined or included within your codes. So early on, we talked about the difference between a consecutive and a concurrent sentence. And Gila River's code is one that gives an example of where we see the distinction being drawn in their law and order code between consecutive sentences and concurrent sentences. Again, this is not exclusive. Gila River's not the only tribe that has this, but this is one example. So if you're looking to incorporate a definition, that would provide you an example of one tribe that's doing that. We also mentioned early on in our terminology discussions, suspended imposition of sentences, also called deferrals. Again, this is not exclusive, nor is it the only tribe that has an example, but the Ute Tribal Code at 1821 provides an opportunity for suspended imposition of fines and imprisonment. And so this is an example of how that can be incorporated into your code. And also, it's kind of interesting here that there's some specific references to domestic violence and counseling within their code. Also, I just wanted to mention these suspended imposition of sentences are pretty common when we're looking at, using alternative sentencing options that are available to the court, such as diversionary courts or diversionary programs. And so if you have a tribe, if you're a tribe that has a healing to wellness court, or you're looking to implement a healing to wellness court, this is also something, an important kind of provision that you might want to include and provide an option for your judge to be able to suspend the imposition of sentences in order for them individuals to be deferred over to programs like wellness courts. And this is really kind of a part where I wanted to give you some examples. Also, I had mentioned that, we've talked a lot about enhanced sentencing authority, about jail time, about, along with these longer terms of incarceration come concerns about, changes that people might undergo during the period of a long-term incarceration that might, make it not feasible or not, effective or efficient to have that individual with ongoing incarceration. And then also some of those collateral or unintended consequences that can serve as obstacles for reentry of individuals is something we want to be aware of. And so Cherokee Tribal Code gives an example. They have some provisions that allow for sentencing corrections and modifications. um, that if there's an error, that it can happen within 7 days after the sentence. So, the court can on its own correct a sentence if there was a problem with the way that the error was, or the court order was drafted. Clerical errors can also be corrected. A couple of others that I wanted to point out that allow other tribes that have some sentencing modification provisions. Chickasaw tribe has a pretty extensive section in their tribal code that addresses uh, modifications to sentences and what are the considerations that will go along with that. Wind River has a little bit of a shorter section, but they too have some provisions that apply for when a sentencing reduction can happen or not. And then Eastern Band of Cherokee also has some good provisions and extensive provisions that will guide the court through correcting or reducing or modifying a sentence after it's been imposed. This is more kind of on the Cherokee Code. The first provisions were there on correcting clerical or clear errors, but there are also provisions within the Cherokee Code that would allow sentencing reductions or modifications within 6 months after the entry of judgment. It would require the party to file a written motion, and for the court to consider whether or not there's been substantial rehabilitation. And then you can also see that there's another opportunity for sentencing reductions after a 12-month period within the Cherokee Code, if there's been substantial assistance provided by an individual towards an investigation and prosecution of other crimes. And so, when you see kind of any of you that might watch some of these television shows where, people who are already incarcerated will say, I want to strike a deal, I want to get time off my sentence. This is what it's referring to, right? So if you have an individual who's already incarcerated, but they have information about ongoing criminal activity, and if they provide that and it's helpful to the investigation or prosecution, this provision under Cherokee would allow that individual to file a motion and request a reduction of their sentence due to that compliance and cooperation. So that's kind of interesting. I haven't seen that in a lot of tribal codes. That's a good example. And then we kind of get into expungement. Again, Cherokee has provisions on expungement, so we just kind of laid that out for you, what that might look like. There are other tribes that do also have expungement provisions in them, but this is just one example. In Cherokee, in order to seek an expungement, there has to be a motion that is filed that will bring it to the attention of the Cherokee court. The individual, if they have only one conviction, no other convictions in state or federal court, etc., you see how this kind of lays out some of the factors that the court can consider. And if these are all met, then the individual can seek and attain expungement. And expungement is a kind of a pretty big deal for an individual because if an expungement occurs, then that doesn't show up on their records, like when they're applying for jobs and doing other things of that nature. And it may or may not be appropriate in different types of cases and circumstances. And so if you are drafting or you have expungement provisions, really taking a clear look at those and deciding, are these really the types of cases that we want to see expunged or not? And that's going to be an important part for your code developers to discuss. Pardons are another thing, and I think we haven't seen a ton of pardons that happen across based on tribal court convictions. But again, as the tribes are imposing these enhanced sentences, requesting pardons is probably going to become something that tribes are wanting to take a look at. One example is Turtle Mountain has a tribal board of pardons. And so you see these pardon boards in many states across the nation, and tribes are starting to do this too. So, if you have an individual who is seeking a pardon in Turtle Mountain, they have a board of pardons that will handle that. Um, Lakota Ray, they have a little bit different process, and their executive branch is involved for pardons and forgiveness. So two different kind of examples of how pardons might be addressed within your tribal laws and tribal codes and procedures. So that kind of wraps us up. We've talked a little bit about, what kind of sentencing options are out there. We focused in on incarceration and enhanced incarceration options. We've talked a little bit about some of the issues that can arise after an individual has been sentenced by the tribal court, and the importance of tribal code developers and tribal judges having mechanisms in place to address things like requests for modification or changes to a sentence, to address pardons and other things. So with that, I'm going to kind of wrap it there. And I don't know, Chantel, if we have any questions, but I think I can hang on here for a little while and take questions.
Yeah, it looks like we have one question that just came in. And the question is, are there tribes authorizing non-imprisonment sentences over the imprisonment limits? For example, 4 years of probation or a 4-year suspended sentence with no threat of actual jail time over a 1 year or 3 year with TLOA. And then are there impediments other than ICRA to such longer non-incarcerated or incarcerated, or sorry, can't pronounce what that is, sentences.
Yeah, no, that off the top of my head, I can't pull you an example. I'm sure we could find some examples. There are, but it's a really good question. So, instead of, so for example, when we've just, for the kind of larger group, if we're talking about that an individual can only be sentenced to a year of incarceration, but instead of sentencing someone to a year of incarceration, the judge sentences them to 2 years of probation. And is that or is that not permissible? And really, we're kind of looking at it probably is going to depend upon what happens during part of that probation and whether there's a real issue with that or not. I'm not aware of any case law that is tribal specific that would prohibit that. But I think it raises an excellent question and also provides an alternative to people. Now, there are provisions within the Indian Civil Rights Act that, even with respect to fines, that you cannot be excessive in what you're doing with your sentencing. So do keep in mind that even though there are provisions within the ICRA that speak directly to 1 year or 3 years, if it's enhanced sentencing authority, there are other provisions which we mentioned that would kind of require people that the courts not impose excessive penalties on people. So that would be what would come into play.
Michelle, I also think that most of those sentences would be done by agreement. And that would be something that an attorney would probably assist their client with so that there isn't an appeal issue in regard to that.
Sure, yeah, if there's plea agreements and the parties had the opportunity to review those plea agreements and had legal counsel to do so, yeah.
Yes. And then we also had another question that says that they were looking for examples of tribes that have contracted with state or local jails or prisons to handle tribal court convicted persons.
They're looking for examples of that.
Yes.
Um, I know that that's happening. One of the tribes here in North Dakota, I know they had, it's in the Devil's Lake, North Dakota region. They had a contract, for bed space within the state facility. And there are several others. In fact, we do work on an intergovernmental collaboration for law enforcement project through Department of Justice and BJA. And if I'm not mistaken, I think we might actually have identified some tribes that have detention agreements. I can follow up on that if whomever asked that question wants to um, provide you with their information, Chantel. Maybe we can get them some more information on that that's more specific than what I just provided.
Okay. And that may be something that we can add to our materials that we send out afterwards as well.
Sure, that may be even better. Yeah, easier.
Great. Thank you. I am not seeing any additional questions. So if anybody does have additional questions, you can always contact us afterwards, and we can follow up with you on those questions. And I think for the sake of time, we'll go ahead and thank everybody. If you want to advance to the next slide. Okay. Thank you all for attending today's webinar titled Criminal Sentencing in Tribal Courts and Post-Sentencing Options. And thank you again to Michelle Rivard Parks, Associate Director of the Tribal Judicial Institute, UND School of Law. Again, the webinar recording will be posted on walkingoncommonground.org and will also be sent out to our mailing list. There will be also a copy of that PowerPoint as well. And we have a copy of QR code on the screen for our evaluation. We also will have that link in the chat as well. And we definitely appreciate you guys taking the time to fill that out. This webinar is a part of a series of monthly webinars to support the development and enhancement of tribal courts, tribal justice systems, and intergovernmental collaborations. These webinars are brought to you by the Tribal Law and Policy Institute, the National American Indian Court Judges Association, and the Tribal Judicial Institute UND School of Law. The next webinar will be on Wednesday, July 2nd, and that is titled Data Collection Best Practices for the CTAS Purpose Area 3 grantees, but is open to the public as well. And then we have another webinar coming up on July 16th titled Juveniles and Young Adults in Corrections and Probations. And they will both take place at 10 a.m. Pacific time. The registration links are available in the chat and will be shared with attendees by email along with today's webinar recording and materials. And again, please take some time to take and fill out that evaluation. And thank you again for joining us today, and we look forward to seeing you next month.